Good evening, ladies and gentlemen, brothers and sisters. Thank you for taking the time to attend our LawWorks Legal Primer series titled Breaking Chains or Breaking Rules, Flex Work and Restraint of Trade Clauses. My name is Khadija. On behalf of Bono, SG and NTUC, we would like attending in session. And before we begin, there are some housekeeping matters to take note of. Today, we'll be using Pigeonhole live for our question and answer session. You may submit your questions at any time during the webinar, and you will vote for the questions by others that you would like answered. If you have a smartphone or a tablet with you, please launch your internet browser and enter www.pigeonhole.at into the address bar. Then key in our event passcode, which is LawWorks 2402. That's LawWorks in caps 2402, as shown on the second page of the slide. Alternatively, you can click on the link in the chat function to launch Pigeonhole live on your device. And if you are viewing this webinar online, you use your desktop or laptop, and you should have had the invitation to launch Pigeonhole. Finally, please note that today's discussion is not intended to substitute any form of professional legal advice. If you do require specific legal advice, please consult a lawyer, or you may engage the panelists separately. And for today's session, we will hand over to Assistant Secretary General Patrick and Head of Legal to conduct today's webinar. Patrick, over to you.
Thank you for making time to come here all the way to the center and online. Is it better? All right. Yeah, because we are beaming it online to all of you, so we make sure you get the sound and whatever that you're sharing loud and clear to each and every one of you online. And for the benefit of you, all of you online, we have an audience here, right here in the NTUC Center. And on behalf of the Labour Movement, we welcome all of you to the Labour Movement's premises here in NTUC Center. For the benefit of all of you who are tuning in for the very first time or attending this LawWorks Legal Primer, LawWorks is a partnership between the Pro Bono SG as well as the National Trades Union Congress. It's a collaboration which has lasted and journeyed almost more than a decade. And what we do is what I call the three-piece meal. The first piece is we do a monthly legal clinic for union members. Secondly, we do a series of, we call it the pocket series, where we come out quick reference guides for each and every one of workers and members to download off and useful guides to help you navigate many employment and work-related issues. And thirdly, legal primers. We do this very frequently on important topics and topics which are close to many of our hearts. And so this evening, we have the honor to have two very distinguished lawyers with us. First, and of course, friends of the Labour Movement as well. Both Toh Wei Yi, a partner with Harry Elias, doing dispute resolution and a lot of the commercial and civil litigation work. So a big thank you to Wei Yi. You'll hear more from her later. And of course, Yeoh Lian Chuan, partner with us, KhattarWong. He's here because essentially Lian Chuan is very interested in this employment sphere and has given a lot of views and has a lot of views as well. So you'll hear more from him later in this area of employment. And in particular this evening, we have two very exciting topics. Because if you look at it, what's happened this year is that there are a few major pieces of legislation that have been introduced. We all heard of the upcoming platform worker bill, as well as upcoming workplace fairness legislation. But over and above that, there are also a couple of tripartite guidelines that are being fleshed out. And one of them being the most recent one on flexible work arrangement and the right to request for it. And another one that's been announced, not fleshed out yet, which is a tripartite guidelines on restraint of trade. Something which many of you who have restraint of trade clauses in your employment agreements will be very concerned about. I want to find out more. So this evening we have both Lian Chuan as well as Wei Yi and myself together to clear the air on this. And shortly, I'll get Lian Chuan to kickstart this evening's event, followed by Wei Yi to share more on both the areas of flexible work arrangements and restraint of trade. But how we're going to navigate this evening is that besides the pigeonhole which was shared earlier to each and every one of you, what we have done is we have broken this evening's session into 3 parts. First part, sharing both by Lian Chuan and Wei Yi on these 2 important areas of law. And secondly, we will have some cases and case scenarios, real life case scenarios, so that we can help you dissect and navigate and provide some answers and practical handles on how to manage some of these scenarios and situations. And thirdly, we'll have a Q&A which will open to the floor to take all your questions where possible, where we are able to answer them. We will try to give you the best possible answer that we can provide to each and every one of you, within the perimeters of what we are able to. And more importantly, we hope all of you participate in this session actively, including those tuning in online, as well as all of you audience here physically, because I think it's meant to be a really a relaxed, informal interaction between our fellow panelists and speakers, as well as each and every one of us. So we hope you make full use of this evening. And again, a big thank you to both Lian Chuan and Wei Yi for making time this evening on a Friday evening to be with us and to share the intricacies of these 2 important aspects. So firstly, I'll just kick it off with Lian Chuan sharing a bit, to give you a bit of an overview on the flexible work arrangements, tripartite guidelines, particularly the recently announced one on the request for flexible work arrangements. So up to you, Lian.
Yeah. Hello.
Yes. The online audience.
Oh, okay. Yeah. So I'm very honored to be here today, and I think it's a very much a sort of a changing world of work. In the last 10 years or so in Singapore, certainly a lot of things have happened, and I was going to say Patrick personally has driven a lot of these things by his continuous efforts over a decade. So I think this has, in a sense, resulted in a more sophisticated labor law landscape. Right? People used to say Singapore's labor law nothing. It's bare bones. But that's no longer the case, I think, and rightly so. I think that's for the good, right? I'd like to start with a very quick anecdote about the legal profession itself. My profession, right? And it's been said to be a greedy profession because it eats up a lot of hours. The Nobel Prize winner for economics this year, Professor Claudia Goldin of Harvard, right? Her life's work was really about the role of women in the labor force, and so she kept describes how that changed over a century in the US, but she talks about the legal profession specifically and how it's historically been very greedy, meaning you have to put in a lot of time, and there's no flexibility, right? But will that change? So I think that's something that we face. And another thing we face, specific to my profession, is we have talked about the right to disconnect, for example, which is a strange and unusual element of flexibility, right? Not within the usual working hours, but actually outside it. Can we have flexibility not to work when we're not supposed to be working? That's a challenge, and it's not easy. But law firms have to grapple with it. There was stories I read in newspapers of a very famous top-tier law firm called Slaughter and May, very famous, and they are really at the top end of the market. You think, well, can they adopt flexibility, right, to allow people to disconnect? Not answer emails between 10 p.m. and the next morning 6 a.m. That's their policy. So they've come up with some policies about when you cannot answer emails between 10 p.m. and don't know what time early in the morning. But that shows that even at the very demanding level, people have to think about it. So I think it's universal, right? So the thing about this flexible work arrangement, I think I put down this first I read is, why is it a good thing, right? For companies and employees, and you're trying to be win-win about this, right? So if I've listed on the slide what are some of the plus points for employers and employees. What this does really is to generate hopefully a more inclusive workplace, and that's really a goal. I think it has potentially a lot of significance for women who have traditionally had a greater share of the caregiving role. Caregiving is also of importance to Singapore because our population is aging, right? In terms of FWAs, I think one of the basic questions we'll face is how far will this become a norm in the workplace, right? As opposed to being, peripheral. I think it's fair to say Singapore is still at a relatively early stage in our journey, and we are looking to find a new equilibrium after COVID-19, right? COVID-19 was really a breakthrough in terms of this because it showed the possibility of and the feasibility of flexible work arrangements at scale. Many things that we never thought possible in 2019 are now seen as, well, certainly possible, if not the norm, right? So that's significant. Another great benefit to me of flexible working arrangement, and particularly work from home, is the reduction in commute time. So I read NTUC's paper on this, and it cited from a 2017 commuting and well-being study from the UK, which found that the effect of a 10-minute reduction in commuting time was equal in terms of job satisfaction to a 19% difference in wages. True or not, it's a significant point. And the last point I would make on this broad overview is that better work-life balance actually will lead to better mental health outcomes. Right? I think that's a big deal, in terms of promoting the interests of working people, as a whole, right? Mental health. Okay, so if I can go to the next slide. Very good. Where's lost mic. Too many pieces of paper. Sorry. Sorry. Okay, thanks. Yeah. Okay. So that's the objective, right? I think it's important, I think, to take the right spirit for both employers and employees in looking at this, and the spirit is really that of give and take, right? So for employers, things like, if you can't give what the employee wants, is there an alternative? And this provides greater transparency, and I think employees should look at this in a responsible manner, right? So, you can't just say, I want it and therefore I must have it, right? So maybe other people may need it more than you, and you have to look at it not just from your own perspective, but from the perspective, of the company, right? There are a broad range of types of flexi work, and it's not just one thing, but a whole range of things. The guidelines, and the materials that the authorities have put out show three main categories, right? The first one is work from home, really, flexi place, working outside your usual office. The second one is where there is flexibility about time, right? Not about the total volume of work, but how and when you're going to do it. So flexi time, and the last one is flexi load. Okay, so to help people sort of drill down into that, the TAFEP website has actually listed a whole variety of categories for things in the flexi time and flexi load space, So this is a listing of all of them. I won't go through each one of them, it's no time, but you can go to the TAFEP website and have a look at them, and I think get a better idea of what are the types of, flexibility that might be possible. So I think that's a useful piece of information on TAFEP's website, right? So this is for flexi time, and this is for flexi load, right? So there are different categories there, right? One thing that has happened this year in Singapore is that we've introduced new tripartite guidelines for flexible work arrangements that apply across the board, and they are sort of quasi-mandatory. It's still important to note that Singapore has not adopted a legislative approach. We're not saying this is law, right? But these are guidelines backed by the tripartite partners, the industry the employers association, the labor movement, the government, right? So there's strong backing for that, but it's still a non-legislative approach, and it applies across the board. Who does it apply to? It applies to all employees who have completed probation. And the reason for having probation is if you're a new employee, the employer and you are still finding out about each other and feeling your way around. So probation is a period which allows that to happen. And so this regime is intended to kick in after probation. Nothing to stop, employers employees who are not yet there in doing probation or seeking jobs, from using this, but the guidelines are targeted at post-probation. They are targeted at all employers. I think that's important. There's a contrast, for example, to the fair work legislation, right? The workplace fairness legislation, which for a start will exclude the smaller employees. They are subject to TAFEP guidelines. So there's a differentiation, but in this there is no differentiation, right? It applies to all employees and all employers. So the guidelines are targeted at a form of formal guidelines, right? Where if you submit it, the employer must, under the guidelines, consider it. But they don't displace completely, voluntary informal mechanisms. So you are free as an employee to informally make requests for your employee, and these requests, because they're informal, can be in writing, can be verbal, and what they may do, because they are less formal, is that they may help in certain situations from preserving a harmonious workplace arrangement. That said, I would argue that from an employer's perspective, even if you have a well-working informal process, it shouldn't stop you from having good corporate flexible work policies, and you should have policies. So having a structured process isn't for employers who don't have the capability to work informally. It should really be a process in place for every employer, right? So I think it's a good thing for companies to have policies, so that makes the requirements clear. Companies can set guidelines, and it also has signaling effect to signal the acceptance, of the acceptability, of FWAs. And actually having policies, I think, is an important factor if you want to have a successful implementation, right? So the structure of a formal request, right? You can make, employers have to put in place a process to manage these requests, including things like how to submit the requests. These things should be communicated to employees. Employers are, I think, encouraged to, and I think they all should, stipulate guidelines on what they expect from the use of FWAs, right? So including things like what kinds of flexibility are allowed, what are some of the criteria that the employer thinks may be relevant, and what are some of the expectations that employers and employees should have, with respect to contactability, with respect to work deliverables, with respect to how performance will be evaluated, So some things like performance management are actually quite important, right? And so, those are things that employers can build in, right? So, I think employees, if you want to put in a formal request, I think it's part of the guidelines that you should act responsibly. You have to do it in writing. If the employer has requirements, you should follow them. And there are some basic things that should be in a formal request: the date, what is the flexibility you're requesting for, the reason, and the start and end date, right? So the employer then must properly consider them on a case-by-case basis. The determination is factual and applies to each individual employee. You are encouraged to discuss. So to have an open and constructive discussion is encouraged. Employers are encouraged to explore accommodating, even if not necessarily in the way that the employee asked for. You should give a decision in a timely manner, depending on the sensitivity. So some requests may be very time sensitive, some may not be so time sensitive, but there's a 2-month time limit anyway. And if you don't agree, you are free to disagree. It's not the guidelines don't want employers to give, but if you don't want to give, then you should provide a business reason and shouldn't give a reason not related to the business. And then in terms of what happens if there is no agreement, then the framework envisages, using the internal grievance process, right, to handle concerns. So the company's own labor, management process, that's the primary mechanism to take things forward. There is no, appeal to the law, if you like, under this framework. The unionized employees can, of course, seek the guidance and support of the unions to give them guidance and help, right? Patrick later on can perhaps elaborate on what are some of these forms of assistance. And I should just flag that, if you do these things, then maybe you need to change your employment contract. That's one point to note, because, for example, if you have a fixed place of work now and you want to deviate from that, then that's a different thing. So that's what I wanted to share about the FWA framework.
Now that we completed the first part, what is the message? The last couple of years, there's quite a number of interesting cases that come up. In this space of restraint of trade, very, very exciting cases, with big names involved in the last couple of months alone. So I think this has drawn a bit of interest, and therefore I'll hand the mic over, and later on then we'll discuss some of the scenarios. But before that, we'll get Wei Yi to share more on this area of restraint of trade. Yeah.
Hello. Thank you, Patrick. Thank you, Lian Chuan, as well. I think the honor is ours, to be invited here tonight. Good evening, all the participants who are here and as well as those online. Well, my role here is to speak a bit more about the restraint of trade clauses. Now, these clauses, they have been around for a long time. And for a long time, I think they have caused a certain amount of anxiety amongst a lot of employees. And I think it is about time that it is addressed. Because honestly, in my line of work, I hear a lot of misconceptions about restraint of trade clauses. And I think the problem is that the law on this is rather inaccessible to the public, unlike things which are stated in the Employment Act. So I think really these guidelines that are coming out in the later part of the year, very much welcomed and very much look forward to as well by the legal profession. Okay, so maybe I can just start by clicking this. So restraint of trade clauses. Okay, generally, a clause where one party agrees with another party to restrict his liberty, his freedom to trade with other parties in the future will be considered a restraint of trade clause. Now, typically in employment contracts in Singapore, and I think elsewhere as well, you will see two types of clauses. One, the non-compete clause, which prevents the employee from working for a new employer whose business is in competition with the former employer. Then there is another category that perhaps is maybe of less interest because maybe not as commonly found, which are the non-solicit clauses. So basically, the idea is that it prevents the employee from soliciting the former employer's customers or suppliers, or soliciting the former employer's employees. So meaning you can't move to a new company and start recruiting from your former employer. So generally for non-compete clause, it's very simple. Basically, it prevents an employee from plying his trade in future. That's what it is. Now, I hear a lot of people assert to me that there's nothing to worry about, restraint of trade clauses are unenforceable. That is not actually true. They are not always unenforceable. It is true that the courts view such clauses very unfavorably. For the anti-competitive nature. It's very much against public policy also to be depriving the employee of a future job role. So it is viewed upon very unfavorably, but it is possible for it to be enforceable. The view that the courts take is that these clauses are generally presumed to be unenforceable unless the employer can show that two main requirements are met. Okay, and the two main requirements are, first, the employer must show that it has a legitimate proprietary interest to protect by the clauses. And I will go a bit more into that later. And the second requirement is that the clause must be reasonable. Again, there are certain aspects that the court looks at when the court determines whether or not a clause is reasonable. Now, when I said earlier that I think part of the problem with restraint of trade clauses is that the law on this is very inaccessible to the public. It's because it is not in the legislation. So you can't just, go to the government website, look for a statute, look at what it says. It is court-made law, it is judge-made law. So what happens is that cases come up, employers try to enforce the clause. The judge looks at it on a case-by-case basis, in fact. So considers the factual matrix, considers the clause as in question, and then the court decides, okay, in this case, is the clause enforceable? Then, so cases like these are decided. Next case that comes along, what was decided in the previous decision has to be taken into consideration if the cases are similar. So it is this sort of way that the law is made, which, as you can tell, it is very difficult for a layman to access and to understand. Honestly, it is complicated for the lawyers to navigate as well. So this, I suppose, is why really the guidelines are very much welcome. Now, if I can just move to the next slide. Okay. Where am I at? Sorry. So this is what I mentioned earlier. Okay, the first requirement of the two that I spoke about, a legitimate proprietary interest. Okay, I want to emphasize that these are very general descriptions as to what the court considers may fall into the category of legitimate proprietary interest. It does not mean that just because you fit into any of this description, it will be held that, yes, there is an interest to protect. So, for example, if we were to take the first thing, trade secrets. Okay, practices, processes, information that is not known outside of the company. Now, this sort of overlaps very much with confidential information. So, yes, they may fall within the same category, but I think there can be certain things which may, how to put this, they are not so straightforward in terms of being confidential information. And the important thing to note is that if in the contract you already have a very robust confidentiality clause, then from the court's perspective, what the court will see is if your interests in maintaining confidentiality can be protected by your confidentiality clause, then there should be no need to stop this employee from working for another employer. Okay, it would then be considered unreasonable. Okay, so you're essentially you have the protection, but you're just trying to ensure, that to make sure that this employee doesn't get a chance at all to leak it to the next employer, which the court deems to be unfair. Trade connections, basically customers. Okay, a company's customer, the company's business. I suppose as a matter of common sense, you can see why that is fair. When the company has spent a certain amount of time, effort, expense, okay, in building up these relationships with the customer, I think the court considers that it is proper that the company can be given some measure, some leeway to protect this interest. The third thing, I think it pertains more to the solicitation of employees. Now, the court recognizes that companies have an interest in maintaining a stable and trained workforce. So again, the company has spent time investing in time and money in training up its employees, up to a certain level, so they can perform at a certain level. It is something that the company is entitled to protect. Now, on the second requirement of reasonableness, generally three things are looked at when the court considers whether a clause is reasonable: duration, geographical scope of the clause, and of course the scope of work and activity that's being considered in the clause. So very commonly, I think duration is of great interest. Okay, I say this from experience, from looking at the cases. Of course, I have to caveat that every case is looked at separately, but generally speaking, 3 years, too long. 1 year, probably still too long. 6 months, you may stand a chance, depending on whether the rest of the clause is reasonable depending on the profile of the employee. Okay, but again, this first and foremost will ever only be considered if the court finds that there is an interest for the company to protect. Okay, so it's dual, the requirements. You need to meet both. Geographical scope, very often you see a lot of clauses, they're silent. They just say that you cannot be working for an employer in competition with who's in competition with your current employer. Often that suggests, when there's no scope included, that suggests whole of Singapore. We're assuming that we're talking about an employer who only operates within Singapore. Generally, that's probably considered too wide. Okay, it is not reasonable because you imagine the employee cannot find another job in Singapore in the same industry and working the same role that he was. So that is extremely unfair. Probably will not be upheld. Sometimes you will see in clauses, they will give a radius, 2 km radius, 3 km radius. So at least that's something for the court to consider. Is this reasonable that perhaps maybe for example, you take the business of a hair salon. Okay, you cannot open another business within 1 km radius of your former employer. That might be some leeway to say that that's reasonable, right? So assuming your customers are the ones who live nearby and who will patronize you out of convenience. So opening a business within 1 km may truly affect the former employer's business. But then again, that is also subject to everything else meeting the requirements. And the next thing, scope of work and activity. Now, this is something also that the court considers. Okay, many clauses will simply say you cannot work for a new employer who is in direct competition with your former employer's business. That actually is usually viewed to be too wide. For example, an employer can have 10 areas of business, can be into selling medical supplies, providing maybe emergency services. So to say that you cannot work at a new employer who's in competition, it means any of these services, of these 10 services that the former employer provides. If the next employer provides maybe 5 out of 10 of these services, arguably it meets the definition of being in direct competition. So that usually is considered too wide. Very often the court will consider this employee. What did he work as? What was his role in the company? Okay, there's only a possibility of a real disadvantage to the former employer if you have something, some skill, some knowledge from the former employer to bring to the new employer. So you are working in a completely different field. It is completely unfair to be restricting the employee to be joining a new company and playing a role that's very different from what he was playing in the former employer. So if we look at generally, if you were to have the misfortune to have to read those very long cases on restraint clause, of trade clause, you'll see that generally the court looks at certain considerations of the employee. The nature of work performed by the employee, okay, the seniority, skill level, the access to confidential information of the company, things like the company's strategy, the company's internal policies, maybe the strategy for the coming 6 months, influence over customers, influence over other employees. Okay, and for the employer also, they will consider the nature of the employer's business, the type of industry, the geographical scope of the former employer's business, maybe the type of information that is typically handled. Now, I think it's fair to say generally, the higher up you are in the management, it is usually assumed that you have more access to confidential information. Okay, and I mean, to be honest, really, for most rank and file workers, it probably will never meet the requirements for the ROT clause to be enforceable. Now, I wanted to point out one item that's quite interesting, influence over customers, which brings to mind, so what if you are in the position of a salesperson, right? A sales promoter. You see, knowing your customer and having influence over your customer is a different story. Okay, so yeah, I'm the sales promoter. I know I'm selling the products. Of course, I know who my customers are. But are you in a position to influence the customer to bring his business elsewhere? That's key. Okay, so if you are, one of the many sales promoters that the company has, chances are you probably will not be in a position to exert the sort of influence over the customer. Now, if you were the head of sales, the regional head of sales, who has been with the company for the last 15 years, and we've got a very good relationship with all the customers, that might be something that the court takes into account. So, so I just wanted to highlight this because I think many people are in sales jobs, and there's this concern, that you have that interaction with the customers. So yeah, it's not as simple as that. It's not just I know the customer, I have the customer's telephone number, and therefore this is going to apply to me. So that will conclude my presentation. I think we should probably take it to the scenarios next, so we can answer some practical questions on it.
Thanks, Wei Yi, and really a big thank you to Lian Chuan and Wei Yi for setting the stage for us to share some of the scenarios and provide some answers and address some of the issues arising in both in the area of restraint of trade as well as flexible work arrangement and the right to request for flexible work arrangements, which its tripartite guidelines will be fleshed out and has been fleshed out and will be effective 1st December this year. Let's go to scenario 1. I think for the benefit of those who are physically present, you may not be able to see a big bulk of the words because it's quite wordy. I'll read the scenario out. Essentially, these 3 scenarios which we'll be fleshing out were sort of real life cases, but we tweak the names and the identities a bit so as not to prejudice anyone. First scenario, it's Ms. Tan is a sales promoter with company A, and she resigned and joined another company promoting water-related products which are in competition with company A. Company A was unhappy and came to her new workplace to remind her of the non-compete clause in the employment contract. The clause reads as follows: the employee shall not for 1 year indirectly or indirectly solicit or transact business in the field of business in competition with the company from or with any of the company's customers or suppliers except with the prior written approval of the company. The clause the clause further states that the employee hereby agrees that he or she shall inform the company in written and obtain company's written clearance before he or she is eligible to join, establish, partner, or be engaged in a business or another company of the same business trade or same product catalogs range of products. Failure to prior notify or obtain written clearance construes to agreement to compensate company a sum equivalent to 3 months' salary in lieu of notice. Very right clause. We literally take it lock, stock, and barrel. So therefore, pardon me for the length. But otherwise, this is the first scenario. Maybe we let's do a short discussion on this scenario, and let's hear from Lian Chuan and Wei Yi. Yeah, maybe Wei Yi want to kickstart your thoughts since you mentioned about sales promoters and.
So this is it's very common. To be very honest, it's really very common. So that's why it comes to mind. Now, I mean, 1 year is a long time. Okay, I say this based on my experience reading the cases. I mean, 1 year is certainly very long. And I mean, she fits exactly the profile that I was speaking about. She's in sales. There's interaction with customers, no doubt. But is she going to be in a position to influence the customer to take the business somewhere? So it's probably not. I mean, of course, we don't know the exact profile of this employee, but it does not seem that she will be. So, so I think the first issue here really is there's probably no interest, no legitimate proprietary interest for the employer to protect. And I mean, if you look at nature of work, it's unlikely also that she is in. She has access to highly confidential information about the company. But you can't say that the company's product information is confidential. I mean, it's by virtue of the fact that you're trying to sell your products. Definitely, information is beyond the company, probably on the internet as well. You see, so I don't think this is a case, where the court is going to find that there's interest to protect, and also I think very tough reasonableness wise is not going to meet the requirements.
Yeah, actually what we shared earlier as well is just brings to mind some of the cases that personally as well as encountered. Some of the unions as well as union members who have raised this. I think the challenge is a lot of employers, including HR, human capital leads, cut and paste employment contracts. Yeah, so I'm a bit worried. So please, both the employers and those who do up employment contracts, including those of you who are the receiving end of employment contracts, please read your employment contract carefully. Yeah, especially when it comes to such clauses. Why do I say that? Because I've personally seen such restraint of trade clauses embedded in contracts of even low-wage workers. Low-wage workers in low-wage sectors, having such restraint of trade clauses saying that you cannot work as a in this profession for within 5 kilometers or for the next 1 year or 6 months. So quite indiscriminate. And as we mentioned earlier, chances are that such restraint of trade clauses, if it ever gets escalated to the courts of law, unlikely will be enforced against or to the detriment of lower wage workers or rank and file workers in general. I mean, there's a reason why there's a restraint of trade clause, because you're quite high up in the hierarchy with access to some trade secrets information and customer data, and not really applicable for the normal worker on the ground in that sense of the word. So therefore, I just as a call to action or a warning call to some of you who have unintentionally, I'm sure unintentionally, embedded some of these restraint of trade clauses in every single one of employment contracts. Just be mindful of that. Just be mindful of that. And sometimes inadvertently they leave it in, but don't try to enforce it against lower wage workers or rank and file workers, because actually, if you look at the raison d'etre of restraint of trade clauses, it's meant for those a bit higher up in the hierarchy. So I just wanted to use this opportunity to share that I personally come across such clauses in very, very sadly, and you even want to take the poor lower wage worker to court over this. And fortunately, we came in early, the union and the employer, and we escalated the matter, and we tried to mediate and conciliate, and we managed to avert a potential litigation. Yeah. In fact, I wanted to test the case, together with Bono SG, because there's never a case where a lower wage worker has been pushed to the edge of a cliff over a restraint of trade clause. So I wanted to test the boundaries a bit, together with Bono SG volunteer lawyers. But I didn't know, and behold, they got the message. So it was amicably settled, and the worker was allowed to work in within the geographical boundaries, even though it was stated in the employment contract. Yeah. Then try any views or thoughts on scenario one?
Yeah, I think just on this clause itself, I think it's plainly not enforceable, because the first paragraph talks about 1 year for the non-solicit, right? It's a non-solicit. The second paragraph talks about the non-compete, but there isn't actually a time frame specified in that, so not sure what the duration is. So you have an uncertainty problem with that, in my mind. Second observation that I would make, is that this clause, contains a liquidated damages claim, right? The 3 months, you breach the agreement, you got to pay this, or you got to pay back your bonus or things like that, So that's something that I do see employers use, right? As a nice cudgel, if you like, So the law in Singapore is that that if you want to have a liquidated damages claim, that has to be it cannot be a penalty, right? So if it's a penalty, it's not enforceable. So if it's well beyond what the measure of loss is, then that's problematic. But in this employment context, one of the challenges is that it's very difficult to figure out what the loss is. And so, is a liquidated damages clause bad? That's difficult to say in my mind. But that difficulty is a tool that employers can use. They can stipulate it there. So in this case, they have stipulated 3 months. I'm not going to say whether it's unreasonable or not. It's just difficult. One thing I sometimes see employers do is that they say, I can claim liquidated damages, and on top of that, any other actual damages that I can prove, right? So trying to have the best of both worlds, And the question has always kind of been on my mind: is that trying to have the best of both worlds by definition penal? Because if your actual damages are X, you always get X. But even if you're not X, you can claim the specified sum. So that is always more than you're fairly entitled to. It's not an estimate that that's both sides, right? You have an asymmetric estimate. So is the asymmetric estimate problematic? As a draftsman, I'm a bit worried. So I try to discourage my clients from going to do this. The Europeans like to do this, I found. So I see that quite a lot from that perspective. But that's one puzzle. One of the general puzzles, I think, in a clause with a staggered series of restrictions, right? So the restrictions, in my mind, on confidentiality and on solicitation tend to be narrower, right? Because they only target certain things. You can work, but you can't go after your old customers or your old colleagues, or you misuse the confidential information, but you can work. So those are, in a sense, more targeted. And the question is whether the courts will say, well, you've got adequate protection from this, so you don't really need the non-compete, I think they are perhaps, my sense, rightly or wrongly, is that they are probably a bit more acute, conscious of this point, and that's, again, to my mind, a little bit of a shift towards being more sensitive to the position of the employee. If you look at a 10-15-year horizon, if you look at, let's say, my colleagues in the UK, my firm sort of, has got, offices elsewhere, but if you look at that, they are more sensitive to the relationship between, for example, these, between non-solicits and non-competes, for example, and they do think about whether I can justify a non-compete on top of the non-solicits that I already have. I think, in fairness, the Singapore employers have not focused anywhere as much, so they just throw in all the measures. But I sense the courts are beginning to respond to that. So that's something that I think will be relevant. And if there are guidelines that come out on this when they are finalized, then it would be interesting to see what might be said.
Actually, I think from what Lian Chuan said, I think one point I probably should have raised earlier when I was speaking about clauses is this. Now, non-solicit, for example, okay, a non-solicit clause. You're not allowed to solicit the customers. You're not allowed to solicit or fellow employees. The issue, proof is also another thing, okay? And then the employer, it's not just a case where if you move to your new employer and a handful of customers happen to switch over soon after you move to your new employer, it doesn't mean that it looks like you've solicited them and therefore the court will find that you have. Proof needs to be given, proof needs to be shown by the employer. Okay, so even solicitation of fellow employees or fellow former employees, former colleagues, there needs to be proof. So it's not so simple, that just because it looks like you might have, solicited them, that is the way the court will find it. It's not so. Yeah, I also think that, given what we see in the cases, I also do think that if the court feels that the non-solicit is enough to protect the employer's interests, then the non-compete will be considered unenforceable and unnecessary. So in that sense, for those whose contracts have all the clauses in it, yeah, I mean, it is possible that one of it may be found enforceable. Again, subject to all the requirements being met. Okay, but whereas I think non-compete is the one that the court takes the most issue with. because it deprives the employee of his livelihood. So
And interestingly, just this year alone, 2 High Court decisions, Money Smart and Shopee, both rule against the employer to the favor of the employee. So interesting developments in this space as well. And well, we have 3 scenarios, so we shall move to the next scenario. Scenario 2, also in this similar space of restraint of trade. If I may read the scenario, Mr. Wei is a QA/QC, quality assurance, quality control, I suppose, specialist overseeing and assisting with the integration of customer and suppliers for company B. He worked for 2 years before resigning. The company activated the following clause against him when he joined another company in a similar line of business. And the clause states that you accept and agree that within 2 years from the date of either termination or conclusion of employment with the company that you will not work for or establish an individual business or entity which is in direct and parallel competition with the company in terms of its product offerings and services. Thoughts from Lian Chuan Wei Yi?
me first? It is me first. Okay. Wow, 2 years. 2 years is pretty long. I mean, okay. I think I saw a question as well. I think that came in, which, how do you put this? I think the issue that was raised in the question, and over here also, is that I've only worked for my former employer for such a short time, but I got such a long restraint. Okay, I guess the problem is this. If the clause appears in the contract, it's one of those things you sign, and this contract would have continued running if you had worked for 10 years. So it is not so much that the court will look at, you only worked for such a short time. If there was a restraint of trade clause, then it must be proportionally shorter. It is not so much viewed that way. How the court views the fact that you've been working for the employer for a very short time, it's more on the sense that how much of this employer's confidential information have you gained? How much do you know about this employer in terms of strategy, in terms of high-level thought processes of the management of the company? How much interaction have you had with this company's customers? Probably not very much at all. You see, so which then answers the question as to the amount of influence that you have over the customers, as the amount of knowledge of trade secrets. So it affects it in this way, rather than for the court to say, look at this amount of time here and look at the restraint of trade clause time. So it's not that sort of a comparison. So I would say this employee, I mean, it doesn't sound like he occupies a role very high up in the management. And yeah, I mean, he's worked for 2 years. It's not considered a long time. So, this, I don't think, if you ask me, I don't think this clause will meet the requirements overall. But also, I mean, things like geographical scope, I suppose, is one thing. It's not mentioned. So presumably, if this employer operates in Singapore, we're talking that this employee will be prevented from working anywhere in Singapore in a company whose business is not only direct competition but parallel competition. I'm not entirely certain what parallel competition means. I don't know, competing alongside. I'm not sure. So again, the lack of clarity also means that it looks like it would be read very widely, and I think that would be a problem as well.
Yeah, I'm looking at the questions as well. I think in this scenario, it's a QA/QC person. But there's a question on what if I'm doing comms and marketing, where there's nothing proprietary that are, it's just basically the skills and experience of the employee. Well, then in such a scenario, the restraint of trade clause can be enforced against a marketing and comms person. Thoughts from the panel?
I think one of the sort of things about this direct and parallel competition, I think, illustrates the difficulties that sometimes happens when people use a whole bunch of words, right? So when you say direct and parallel competition, does that mean to be competitive, you must be both direct and parallel, or do we mean it's direct or parallel, So sometimes words like and or, think of and as conjunctive and or as disjunctive, but it's not necessarily so. It could be the opposite in those ways, So these kinds of words, create that puzzle, Sometimes a thing to think about when you look at clauses is, can you strike out certain words, right? There's a sort of a blue pencil test, if something is too wide, can you delete part of it? I think so far the courts have said they express skepticism, I think, in the employer-employee context, but whether that's a good thing. But they haven't gone so far as to say no, but if you want to be able to delete, then you cannot rewrite, you can only strike, and if you strike it, it must not change the meaning fundamentally, So the probably a very famous case that reached the UK Supreme Court, name escapes me now, but it was a person, they said you cannot be, be involved, be a member, for example, of a company, and that captured, having a small minority stake, in a listed company or a major group. And if you're drafting a clause and you say you cannot be engaged in or own the company, then you would typically say, you cannot accept the holding a minority portfolio stake. You would say something like that, But in that case, they didn't have that exclusion, so the clause was too wide. And so the question then was, can you strike that particular word, and leave the rest? And I think in that case, the UK Supreme Court said you could, but it's it's a real puzzle that people think about when you look at these clauses, right? But one thing I guess that arises from these durations, what do you want to do for this period? And I think that I'm going to cheat a little bit and look at some of the questions that have come. And one of our top questions is, can the employee ask for garden leave, right? And that's really a question about payment. If I'm on a covenant and I can get another job, fine. But if not, then what am I going to do, right? And so, I think that arises in a number of contexts. One context is, if you have a garden leave clause, it's the period that you take into account the garden leave plus the post-termination covenant, right? So for people's information, if you're on garden leave, you are still an employee. So you're still subject to your duties to the employer, but you may get paid, right? And then when you are if you have a post-termination covenant, then you are no longer the employee. But you have to add the two periods together. That's kind of one when you look at reasonableness. And then I think in terms of payments, right, there are two considerations. One is, can the employer or should the employer offer to pay for the covenant? To say, if I want the covenant, then if I want to enforce the covenant, then I will have to pay X $1,000, right? So is that better or worse? And does that affect the reasonableness? So I think the suggestion is that it probably does affect the reasonableness, and it's probably more reasonable if that the employee is compensated for the covenant. That could be a compensation upfront, right? Or it could be compensation for the period of non-work. So when you look at the period, these are some of the other factors. Is also a factor.
Thanks for elucidating this point on garden leave. For the benefit of the general audience, garden leave is not something provided in the Employment Act. It's unique to certain employment contracts, and particularly certain individuals, usually quite senior in hierarchy, and depending on the kind of organizations in some parts of the world, particularly in Singapore, we have quite a number of multinationals too. They do have garden leave clauses, or if they're embedded into the contract. So it's not a given. Yeah, it's not every contract we have a garden leave. So thanks, Lian Chuan, on addressing the garden leave point. And earlier, as I mentioned on the question that came up on, what we talked about QA, QC, inspector, sales people. How about marketing and comms professionals? I think essentially my point of view is that actually depends on the access to information and data. I think very, very important. Yeah, so you may be a comms and marketing person, but you have no access to. You're just executing, very standard communications and marketing materials, and you're not privy to any confidential data or client information. Then the likelihood of you being a restraint of trade clause enforced against you would be much less mitigated or reduced. So that's to answer the second question. There's another question that came up I thought useful at this juncture, since we're also talking about restraint of trade. The question says, I was laid off but obligated by non-compete and NDA clauses for 6 months. Which restricts my ability to pursue opportunities in the same industry. So he or she was asking, what would be our advice?
See, I suppose probably related. Okay, I mean, I will say that I don't know much about the background of this person. Okay, 6 months, yes, it's not as long as 1 year, but honestly, you need to meet the test first for there to be an interest to be protected. And what should he do? As a lawyer, I can tell you that it's probably unsafe to go on the assumption that it's unenforceable. Just don't bother and just move on. And I think most people will be a little bit more cautious than to really think that way, to be so convinced that it's unenforceable. So, I mean, honestly, I have the solution for this lady or gentleman who has come up with the question. It really is to seek some legal advice. At least the legal advice based on this person's background as an employee. They'll understand what the employer, what business the employer is in, and they can give some advice. It's not talking about bringing this to court or what. It's just some legal advice, and hopefully this can give the employee some assurance whether or not it's a risk assessment thing, isn't it? Right, to give some assurance to understand whether or not he or she is comfortable or prepared enough to move forward into this new job. Which also kind of leads to one of the questions. Actually, more than one question came up. What is an employee to do if the employer refuses to budge on the non-compete clause when you're signing a contract? I think that's a very, very common problem. Honestly, the best thing that an employee can do is really to insist that it is removed. I don't think it really works to leave it in there, and then later on, when termination comes, you are still left with the anxiety. But that's why I think the guidelines that come up in the later half of this year will be very, very useful, because this will serve as I won't say warning, but how do you put this? A message to the employers that certain things are not enforceable. Don't put it in the contract. I think right now, something that someone asked was also, why do employees put it in the contract if you know it's unenforceable? I think, unfortunately, one situation is employers just cut and paste. I think another situation is that employer just hopes that it scares the employee enough. Okay, even though that by the law it's unenforceable, but it scares the employee enough because there's not enough information in the public sphere to allow the employee to understand that it's not enforceable. So I think when there's more information provided to the members of the public, I think it will also help solve that problem a little bit.
Any further things before we go to the last scenario? Well, later on we still have Q&A, so not to worry. Keep the questions coming in. I see the pigeonhole is quite full, but I think we try to power through the third scenario before we do the Q&A. Since we only have something like 25 minutes left. Scenario 3, in a very, very important area of flexible work arrangements, as well as the latest tripartite guidelines on the ability to make a request for flexible work arrangements. So this is something new. As Lian Chuan alluded to earlier, it's a set of tripartite guidelines. It's not going to be law. It used to be sort of like advisory and standards, and now it's been upgraded to a tripartite guideline. And so take full note of it. Why do I say that? Because although Lian Chuan earlier used the word quasi-legislative effect, he's quite right. Although the tripartite guidelines are not law, well, there's some quarters that say it lacks teeth. It's just mere guidelines. But I must emphasize, because of the practice I've been involved in representing workers and unions in going into the Industrial Arbitration Court, that a lot of weight is given to tripartite guidelines. Yeah, I've appeared before the court on many instances, and in the grounds of the decision in the judgment delivered by the president of the IAC, has actually alluded to many of the different sets of tripartite guidelines along the way in those different cases. So it does have, I would say, very persuasive. These are very persuasive authority. And we have seen the likes of it recently, as well 2 months ago, in the district court, in one of the judgments, where one of the district judges did allude to the fact that she had to give weight to tripartite guidelines because it's quite odd to do something that's really off tangent with the set of tripartite guidelines, which is actually a tripartite practice in the across the industry and among the tripartite partners. So that's the second indication. And also, if it's of any help, if I recall, Section 20 of the Employment Claims Act actually does allude to using the tripartite guidelines on wrongful dismissals as well. So there are actually instances where tripartite guidelines are explicitly referred to. So do take them seriously. In case some of you who are employers or human capital, human resource practitioners who are wondering, should I comply with them or not? I say this not just tongue in cheek, but really frankly, because we'll be sometimes occasionally in the course of industrial relations practice, I've come across some organizations and companies who want to deviate away from the tripartite guidelines, maybe not for flexible work, but for other areas, because we have an entire a plethora of guidelines. So do that with caution. Yeah, do that with caution. We don't want to, name or shame, but push come to shove. Particularly in Singapore, where we have this tripartite framework and a tripartite way of doing things, do comply with the tripartite guidelines where possible. Yeah, so unless you have very, very strong reasons, otherwise, please do so. And I know many of the employment lawyers and in-house counsels have been quite proactive and progressive and responsible in advising their clients, and as well as the in-house departments to comply with the tripartite guidelines where possible. Particularly in Singapore, uniquely Singapore, we have lots of tripartite guidelines and advisories, and you don't see that anywhere in the world. But I thought this message goes out to everyone who interfaces or comes across or have to comply with some of these, especially if you're operating within Singapore and our jurisdiction. Yeah. So third scenario on flexible arrangements, I under flex, no pun intended, under flex some examples of flexible rate arrangement requests. First one. We have 3 employees requesting for flexible arrangements. So we wanted to hear from the panel as well, what position we'll take with regards to this come 1st December. So first is Ms. Lee submitted a flexible arrangement request for flexi time and flexi load. You heard the 3 flex from Lian Chuan earlier: flexi time, flexi load, and flexi place. Yeah, I just want to caveat this, or should I say explicitly say this, that flexible arrangement not equals to work from home. I thought there's some misconception out there, because after these guidelines were released, there was one headline that went around across social media and the world that Singapore is on a work from home permanently kind of arrangement. So that's not true. We're not on a permanent work from home arrangement. It's just working from home is just part a segment of the flexi place that is embedded within this tripartite guideline. So it's flexi time, flexi load, and flexi place. So in this case, Ms. Lee submitted FWA for flexi time and load. She stated that her mother sustained a fractured leg, and she's the sole caregiver of her ailing mother. She would like the FWA to care for her mother until she recovers. Thoughts, Lian Chuan?
I think this example does illustrate something which might justify flexible work, right? Where you need to act as a caregiver. I think that's something that is prima facie a relevant reason. Of course, you still have to look at then the facts as to whether the job, how the job allows for it. I think the employee and employer are best placed to try and have a discussion to see how this can be accommodated, right? And there may be accommodation on both sides. So this strikes me as something which is a genuine need, and the question then is how can both parties act reasonably and see if it can be accommodated.
Yeah, thanks, Lian Chuan, for that. So I hope you caught some of the keywords that Lian Chuan shared on reasonableness, as well as reasons, as well as companies' operational requirements. I thought these are very important points, and it's embedded actually in the tripartite guidelines. If you've not had a copy, you can actually. I think we're going to give you a link to a copy of the tripartite guidelines on the link. On the chat, as well as for those of you, you can just Google it. It's available quite easily, including a PDF copy. Important, I thought to articulate on this is the fact that at the onset, I think Lian Chuan mentioned about give and take and really employer-employee coming together. Obviously, from the plain facts of this request, it's a valid reason. Yeah, very reasonable reason. But I thought important. If you notice the guidelines as well, it does say, employer-employees should sit together and, discuss it out and what works best for the company so that we have a win-win outcome. I think the operative word is a win-win outcome, not a win-lose outcome. I think we're able to meet the needs at the same time also can accommodate the operational needs of the company. Sometimes it's really on a case-by-case basis. Different industries, different size of company. Can you imagine if you only have 2 persons or 3 persons in the company, 1 person down is almost 1/3 operational strength down. So it varies. Compared to a multinational, it may be 5,000 workers. 1 person, maybe they can afford to provide some flex in the terms of time and load. So I thought very, very important in mentioning this. And this is important. This is an important scenario. Why do I say that? Because I think increasingly in Singapore, we are going to, we recently had an Every Worker Matters conversation, and this point on caregiving came out quite a bit. Why? Because many of our parents, grandparents are living much, much longer. Life expectancy is one of the highest in the world in Singapore. So we have not just caregiving arrangements, but some of us have kids a bit later. So we are literally, burning candles at both ends. You have your young children to care for, and as well at the same time, elderly parents and grandparents to care for, or even spouses as well. So I think this caregiving arrangement is something that has been coming out quite a bit, and therefore this flexible work arrangement, the right to request for it comes at quite an opportune and apt time. Simply because I think increasingly there'll be more of these that human capital, hiring managers, bosses will face. Yeah, so I think it's good that we are doing this in a very progressive, very preemptive manner, because of an aging population that's sort of like coming into our faces, and therefore these are important considerations. So I thought good if you see the travel guidelines to actually have some form of policy in your HR policy. If you not already have it, the templates are actually as part of the guidelines and the annexes, so you can use that as some of the templates. And some of these clauses, provisions are all publicly available through TAFEP's resources. And I thought important to share this with everyone because don't worry, you're not alone. It's going to apply to all employers in Singapore, operating in Singapore. And therefore, we totally understand some of the operational concerns, but at the same time also how we can make sure employees are engaged, motivated, encouraged, and it speaks a lot of volumes, especially flexible arrangements. It speaks volumes of employee engagement. It speaks volumes about the branding image of the company, how it treats its employees fairly, not just fairly and responsibly, but also progressively. So I thought just a few pointers and tips to everyone out there. Yeah.
I just wanted to share because there's a personal experience on that. I think, and this is probably for all the employers out there, it's not just, you see, it's not just about, I suppose when you have caregiving responsibilities for like kids, for your elderly parents, I think the issue sometimes is also knowing that you can have a bit of flexibility takes away a bit of the mental stress and the anxiety that the employee faces, in trying to arrange, for example, the coming week, there's medical appointments, things like that. Sure, perhaps it can be done. It can be, you can get other people to help. you know, and it's such that, okay, somebody else takes care of something that happens in the day when I can't be around. But I think it causes a lot of anxiety for the employee, especially when I think a lot of mothers out there might feel that way. It causes a lot of anxiety, just having to schedule, having to consider, oh no, who's going to do what, you know, at what point in time. Can be done, but it takes up some of the mental health, I feel. So I think for employers, you know, when they give that sort of option, I think it's not a case where you think, oh, this person is going to slack off, but it's not. You know, I think it's that flexibility that allows, yeah, I can do my work, but maybe not between 4 to 6. Maybe I could do it at night between 9 to 11 when my child is sleeping. You know, the productivity doesn't go down. You know, but again, I would say, I think like Patrick says, it's important to have that conversation with the employer to understand, for the employee to tell the employer, where am I coming from? You know, what is my difficulty, and why what I propose can solve the problem without affecting the company's bottom line. So,
And can I just maybe, I think it's, you know, the culture of give and take, I think, you know, counts for a lot. And, you know, sometimes these requests can be solved with flexi time, right? Which it doesn't mean work less, you know, so that's a relevant consideration, you know. I think the culture of the management is quite important. So, you know, again, in our line, you know, me and my partners, we try to, you know, be responsive to people's life needs, you know. But at the same time, I tell them, you know, we have high expectations, right? Trying to put in both these messages at the same time, and I don't know whether they're contradictory, but we try, you know. So that's something we do. I mean, I must say that I have been both lawyer in a large firm with, you know, 100 lawyers or more, and also I've had my own team with 4 lawyers, you know. So I think it does, you know, I had a small firm. So I think it, you know, I feel I can say I felt being on the small employer as well as on the larger employer kind of scenario. But, you know, when you deal with a small employer, then I think the employees, you know, maybe speaking a bit with an employer's hat on, you know, I think the employees have to be a bit understanding as well, because, you know, if you are a small employer, you know, you don't have that many people to be flexible about, and that's a real challenge as well.
Thanks. We'll go to the second part of the scenario. It goes like this. Mr. Salim has recently joined the company and is currently on probation. He submitted a FWA request. He simply stated that he would like the FWA for personal reasons. Because if you look at the template of the FWA request, the annex of the Tripartite Guidelines, it does have a nice big box saying, please state a reason. So it says personal reasons. Your take.
Okay, so I think I'll come to the reasons point first, and then the probation. You know, the reasons point, you know, it is a requirement in the guidelines for a formal request to state the reasons. So if you don't state the reasons, or you don't state the reasons accurately, then strictly speaking, you have not made a valid formal request. Your request is whatever it is, but it's not a valid formal request. So, you know, I think the employer doesn't have to, you know, respond to it in the same way, right? Clearly, I think stating, you know, a bold statement of personal reasons isn't good enough. But the question, I think, which is slightly broader than that, is, you know, what is the role of the employee's reasoning in looking at the employer's decision making, right? Because, you know, there is a question of, you know, you say you will give business reasons, cost, productivity, you know, the nature of the job. None of these have anything to do with the employee's reasons. So what is the role of the employee's reasons? And in my mind, the employee's reasons are relevant because flexi work almost always imposes some cost, maybe great, maybe less. It's not cost-free, you know. It's, you know, so often there is a cost. And that's why I think the reasons are important, because if you don't state the reasons, the employer cannot weigh up the strength of your reasons against the potential cost to him. And so that's why the reasons are important, because it's part of that trade-off. So that's my comment on reasons. And then on probation, obviously in this example, as we shared just now, you know, the guidelines apply to post-probationary employees. So this situation wouldn't fall within the formal FWA framework.
Thanks, Lian Chuan. And the final part, I'll do a bit faster because I'll give some time to take questions both from the floor and from the audience at home. And the final part of this scenario 3, Ms. Levy is a frontline staff. She submitted an FWA request so that she has the option to work from home, flexi place arrangement, like her colleagues in the company. Thoughts?
I think the basic question now is, is this job one which is compatible with the flexi arrangement that the employee wants? Try to keep it short as well.
Yeah, maybe just share some thoughts. I think if many of you didn't realize, about a quarter of our workforce in Singapore are essential services. So many a times they are usually frontline in nature. And just imagine lah. I mean, I was just giving you the most extreme example. You ask your SBST bus driver, can you work? And he makes a request of work from home. Obviously, he can't deliver his service to each and every one of us. So is this a clear-cut scenario where due to operationally, due to the frontline nature, I know in terms of customer service now they are increasingly getting it more digitalized, more flexible. Some are not even answering physically in the office, but through a video teleconferencing system. Some are, not even in Singapore and could be at home answering calls. So, I mean, it depends on the nature of the work actually quite a bit. So unfortunately, some of the work is quite high touch, meaning that you need to be physically present and physically meeting customers. So in that case, it's going to be quite difficult. It's going to be quite difficult to actually ask for a flexi place arrangement. If there's an operational requirement that the nature of your job is already face-to-face interactions and a lot of high touch. Yeah, you can't ask a physiotherapist to work from home and then deliver. Well, possible. We saw it in COVID where they tell you to do certain maneuvers and they demo to you on the Zoom. Well, I mean, stretching it a bit lah. I mean, no pun intended, but again, some of these services will require some form of high touch to be able to deliver particular services and goods. Yeah, so that's a quick answer to this question. And which leaves me actually less than 10 minutes away from I'm seeing the hint from the crew behind the cameras, and perhaps before we take even more of the pigeonhole questions, any questions on the floor here? Those physical audience, we give you priority because you took your time and effort on a Friday evening. Yes, maybe share your name and come to the mic so that we can benefit from your sharing. Yeah, we'll take a couple of questions. I said time dependent. Yeah. Just give us a moment.
My name is Suresh. I'm actually a colleague of Wei Yi's.
Yeah.
And this is a question actually for Patrick. I'm very interested in the guidelines for restrictive covenants. And I wanted to know what is the purpose of these guidelines? Is it just to state the current law so that it's easily accessible to everyone? Or is it meant to sort of nudge the law in certain directions? The reason why I say this, of course, is actually the panel members have already mentioned this. The main purpose of restrictive covenants in employment contracts, I've been doing employment contracts for 30 years. I've seen millions of restrictive covenant clauses. The main purpose is to intimidate employees, all right? And when you talk to the employees, they say, you tell them, this case not enforceable, you can fight it. They don't want to fight because you must put your hand in your pocket and you must put money out. Because unfortunately, lawyers also have to earn a living, all right? So that's the main purpose, is to intimidate. Second thing is, there are developments that I'm seeing now that Lian Chuan mentioned. They use liquidated damages clauses, right? So they know I can't get a restrictive covenant, I can't get an injunction to stop you from working, but I make you pay me money. So you said no wage workers, will there be a case? My firm is doing one next month, right?
All right, man.
It's earning $2,000 a month. The liquidated damages clause is 500,000, right? Coming up for trial. So, and The other thing that Lian Chuan mentioned is make the employer pay during the restrictive covenant period. In many countries, if you don't have a compensation clause, the restrictive covenant will not be enforced. But that's not the law in Singapore. There's not been a case in Singapore that has imposed as a requirement. But these are things, when I say, are you trying to nudge the law in a certain direction? These are points that can be nudged.
So Suresh, if I may ask, maybe share with me your suggestion on, hopefully in this tripartite guidelines, what do you hope to see that will help make your job easier and elucidate some of these difficulties? Any few key points that you hope to see?
When you say make my job easier, sometimes I act for employer, sometimes I act for employee, right? So whichever way it goes, right?
Okay.
The thing that makes my job easier is certainty in the law, right? Because then you can give clear-cut answers. But in the space of restrictive covenants, the main issue always is if the employees fight all the way, almost always they win, right? But when you look at the start and say fight or don't fight, the employee says, I got no money to fight. All right. So this is not a problem that can be solved by the law per se, right? But when like I said, if the guidelines are meant to nudge the development of the law in certain directions, the two issues were the ones that Lian Chuan mentioned. And I think that would be helpful. I will say this, when I'm talking to employers, right, or rather when I'm talking to general counsel in a multinational, and the general counsel are the ones that usually insist that the restricted covenant includes a compensation clause, because they tell me this: if the compensation clause is not there, every time the business leader has an employee leaving, he insists that employee must be restrained. It's very, very important. He must be restrained. He's a key employee. He's got all sorts of contacts with clients, all sorts of confidential information. But when the GC says, okay, you'll go to court, but you must pay this amount of money and it comes out of your budget, suddenly the business leader gets a bit more wary about pushing it. So it will, in my mind, if that becomes more of a norm in Singapore, which it is not at the moment, if it becomes more of a norm in Singapore, it may balance the position between employer and employee a bit more than it is now. And the reason why I talk about liquidated damages, because really liquidated damages is in terrorem. It is really meant to frighten people. And I don't like a situation where one party uses its size and bargaining position to terrorize a smaller party, and all employees are smaller parties.
Thanks, Suresh. My short answer is I can't reveal state secrets. So no, but yeah. So I was about to say, yeah. I mean, Minister has come out in the open to say that there'll be a set of tripartite guidelines to give some more clarity on the use of restrictive covenants. If you look at actually earlier on in my sharing, I actually hinted at why we came to this point where we wanted to flesh it out. Of course, there are certain parts of the certain jurisdiction across the globe that has set out laws to prohibit that. Yeah, we've seen some developments there. But essentially, to provide some clarity, earlier on I mentioned about rank and file workers, low-wage workers being thrown with restraint of trade clauses. I thought that's something quite worrying, and we want to provide some clarity on that, I'm sure. So that's one of the reasons, because we are starting to see cases where this is being thrown at very rank and file workers as well, not just the top executives and salespersons. So that's but otherwise, an answer to your question is not a state secret, but at the tripartite level, it's still being discussed. Really, we're still on the drawing block. And just to answer, that's why I asked for suggestions, because we'll take them seriously, and we'll pick your brains. And as well as today's session, to hear some of the point of views, and the panel as well, so that we can do something to help provide more clarity, hopefully more certainty. I don't know how certain you'll be, but like I said, we shall see. But we take your views, and suggestions as well.
Maybe I'll just raise this because I see a lot, quite a few the same questions. Actually, I alluded to it earlier, and I wanted to ask Patrick this because I don't really have an answer. So, I mean, for the workers who see that clause in the contract put to them by the employer and they need the job, there's no way the employer is going to budge. They don't feel like they're in a position to bargain to remove that clause. What is this worker to do? I mean, the nature of my job is that I deal with what happens, later. I honestly, I don't really have an answer for this question, but I feel very much for this question. So what have you seen in your experience?
So that's why generally for rank and file workers, most of them, in fact, we have collective agreements to cover most of their terms and conditions of employment. So we look after our union members and in our unionized companies. And in particular, if some of them face problems in this space, we will try to assist them and advise them accordingly through our legal clinics, through our various industrial relations practitioners and trade union leaders. So we'll try to advise them. I mean, for unionized companies. For non-unionized companies, if you're a union member, you can actually have access to our legal assistance panel if you become a member. And we can provide you some access to justice, as well as beyond the legal clinics, to seek counsel's advice, proper professional advice at a, well, I wouldn't say discounted rate, but at a better rate. Yeah, particularly for union members. So I know many of you are union members, so I thought good to share this additional privilege we have benefit that we roll out earlier this year. Because during our legal clinics, during our primers like this, we do encounter some of our union members, as well as non-union members who want to be on board, including I see some of our residents during my Meet the People sessions where they have issues with restraint of trade. So I thought that will be one avenue that we do to give you some rudimentary advice, but even take it further. And if you're really short at with a letter of demand and even sometimes a writ, then you probably need counsel to represent you and assist you. So that's where you need to take it a bit further. And if it goes that far, you probably need help. And here we are for union members. We have the legal assistance panel. If you need some assistance to at least short of counterclaiming, but at least provide a reply and defense. Yeah. There's a question that came up quite high in the pigeonhole. I'll take 2 or 3 more questions if you all can bear with me. I know we are hit the 8:30 mark, but I thought to give justice to all of you here, as well as those who filed the questions. The question came up that if granted FWA, but individual was caught working a second job during the granted period, what resolution for employer? Thanks. What 4 persons asked. Okay. If I may answer on behalf of the panel, essentially there may be, increasingly we're seeing workers, including younger workers, doing side hustles. Yeah, many do side hustles. They may not be directly related to their jobs. The side hustles may be a YouTuber or social media influencer. These days, a lot of different unique. It can be a musician singing at the bar on certain nights of the day. So there are a lot of people who are starting to do side hustles. So as employers or even as employees, if you, in this case, it's an employer situation, do check your employment contracts carefully to see whether you have built in some of these policies and requirements for your staff or employees. Why do I say that? Because if there's nothing stated there, and there's no HR circular or practice, quite difficult to injunct the employee from moonlighting or doing a second job. So it's good to be explicit about it and have some practice. I know companies that have very progressive practices say that, you can do it, but please declare it, get permission if the supervisor, the line manager, or the HR or the boss feels that it's okay, it doesn't conflict, there's no conflict interest situation if your job or your main job, then please carry on. Yeah, so it varies from company to company. organization to organization and industry to industry. So different practices. And there's a thin line of what's a conflict interest. So I mean, you know best because you're engaging in that trade or business. So be clear about that. Otherwise, even though it's not provided, there may be situations where if it's conflict interest, then the employer will say or hold that against you. So just be careful about it and just be open about it and transparent about it, so that you don't get into trouble later on. Being social media marketer or search engine optimizer or something, or selling things online and stuff like that. So just be mindful of it and declare it. Yeah, and for employers who have to require employees to declare it as well, so that it's all open and transparent. Yeah. Yeah. So I think the second question on the ROT clauses and you're desperate for a job, should I still sign? It's your call, your call. So like what Wei Yi mentioned, you know the provisions, you know the law now. It's your call, it's your call. But she's right. Often you're at the weakening end of the bargaining chip of sorts. And you're not the one in the deeper pocket as well. So therefore, think carefully. Whether you're prepared to take on these obligations in the event that you may, after 2 years, become so popular and so outstanding that your competitor headhunts you and then you jump ship. So think long term when you get into employment, and be mindful of that. So nothing wrong to sign it, but just be mentally prepared for it, especially if you're not for the long haul. I'll take one final question from the floor if there are any. Any from the floor? If not, then I'll take. Oh yes, okay. So I'll give it to the floor then. Yes, please come to the mic.
Hi, thank you so much for all this information today. I think my question kind of has to do with, because now there's a lot of flexi gig work, right? So do these ROT apply to gig workers as well, like adjunct trainers? I think there are some questions there on trainers, educators, or any other form of adjunct workers. Do they apply, and to what limits do they apply? Thank you.
I think first and foremost, it's very hard, given the nature of the gig workers' work, to meet the requirements, both in terms of the interest, the interest to be protected, and also the reasonableness of it. So, I mean, I would say that I personally have not seen any attempts to enforce an ROT clause. I mean, I can't profess to say that I've read every single case available in Singapore, but honestly, I have not come across a case where a company has tried to enforce an ROT clause against a gig worker. But I would think that if it were to come before the court, I suppose perhaps the same test would apply. But like I said, given the nature of the work, I find it very hard to believe that you could possibly meet the requirements.
Yeah. So Wei Yi is quite right. I even in my couple of decades doing this in this space, have not seen restraint of trade clauses for adjunct. However, my caveat is I've seen a few things that happen. Firstly, non-disclosure agreements. I've seen also confidentiality agreements that adjuncts are being forced or required to sign when they undertake certain contracts, including sort of swearing away your intellectual property as well. I've seen that happen quite a bit. Adjunct trainers and stuff like that. So when you prepare a deck of slides and then you do a presentation or use it for training material, education material, and then the ownership and rights actually goes to whoever that organization that procured your services. So I've seen some of these happen. So they have used some of the more creative ways to kind of restrict you from sharing the same deck of slides or same materials or that you have used for this on other occasions. So that's what I've seen, these three scenarios. And these three scenarios, don't take it lightly. If it's an NDA, because the organization will share with you some of the ins and outs and stuff like that, and or certain, of the inside information of its, or they want you to do a piece of research, for example, into their data and stuff like that. So handle with care. Yeah, so take note. Yeah.
Sorry, if I might add to that. So there's 2 points, right? So there's the ROT. So I mean, like I'm a freelancer, so like I've seen some ROTs included, which is like I'm a trainer itself. So like the training material is provided by them, but then I was like, so I understand that I cannot share those materials, but at the same time, the second question has to do with like the confidentiality clause, right? So if they are not sharing their materials with you, and then they ask you to develop the slides, and they are not paying you specifically for those stack of slides, would that still apply? I guess so there's a 2 question, right? So because like the first question for ROT, I'm not sure if there's a copy or paste situation like you guys mentioned. And like how much of that would that apply then? Like, maybe we have not seen it before. And then if one day they decided to, hey, we want to enforce this, yeah, so how should I protect myself? Yeah, and the second one was like if the deck of like any intellectual property that was provided was not specifically paid for, and it's not based on any confidential information on their end, and how much would that apply as well? Okay.
This question actually will be addressed during another primer on intellectual property and personal data. We have like this evening, we had a 1.5 hour discourse on that, and particularly for gig workers. We may do another one in the near future. But essentially, when it comes to intellectual property, particularly if you're using your own deck of stuff, please protect them. Please protect them. Yeah, I know there are now better guidelines, and IPOS has come out with some new rules. I'm not expert in intellectual property, but I know they have come out with some new rules, and particularly in the area of copyright, including for creatives. So there are some safeguards so that if they reuse for example, cameraman, they use your photos, they have to acknowledge it and stuff like that. So we have embedded some developments pursuant to some of the feedback from the gig workers. But otherwise, if they are using your information, your deck of slides, then I appeal to you to actually protect yourselves. When you go on the engagement agreement or whatever agreement that you enter into with the person to procure your services, protect that part of those areas that you want to better protect yourselves with, so that they don't come back and say, oh, now that you've delivered this is my deck, and then you swear your life away. So that's the last we have. So you just need additional protections. And we actually have a pocket series on for freelancers. So you can download a copy. It's available both at the Pro Bono SG sites as well as the NTUC site. Yeah, that gives you a very rudimentary understanding of how to better look after yourself if you are a freelancer. Yeah. Thank you very much. I think we have sort of come to the end. I don't think we have time to get Lian Chuan and Wei to say a few words because it's already way past our end time. But on behalf of the organizing team and the LawWorks team, we thank both Lian Chuan and Wei Yi. Yeah. At home we can't clap, but you can give a wave and whatever you can within the online platforms. And again, I think the team will provide the slides for those who have requested for them. I think we will be circulating the deck, I'm told, and we'll be providing the links for those who are online for you to access whatever guidelines and the materials that we mentioned earlier. And really a big thank you to everyone here for making time on a Friday evening. Hope you have a great weekend. And more importantly, there's some formalities. I don't know whether Khatijah want to come back in to help do the closing. And once again, thank you everyone. And it's been a pleasure to be able to moderate together with my illustrious panel this evening to take on both these two very important topics of flexible work arrangements and restraint of trade. Thank you.
Thank you, Patrick. Thank you, Lian Chuan. Thanks, Patrick. Thanks, Ray, and thanks, Lian Chuan. Thanks everyone online and who's come down to attend our event. And thank you for the questions and your insights. If you're facing any issues and if you're an NTUC member and keen to register for a legal clinic session, you may write to lawworks@ntuc.org.sg. That is lawworks@ntuc.org.sg. If you are a non-NTUC member, do consider to register as an NTUC member, or you can approach Pro Bono SG at help@probono.sg. For our participants joining us via Zoom, after this webinar, a survey form will pop up on your browser for your completion. For our in-person participants, a QR code will be showed for you to scan to access the survey. We would greatly appreciate your comments and feedback on how we can be better. We will use them to improve future webinars. With that, on behalf of Pro Bono SG and NTUC, we would like to thank everyone who has joined us today. Thank you so much for the panelists' insights, for the moderators' views. Have a good week ahead, everyone. Thank you so much.